So if we'll get started. So again, for those who are joining late, I am Chris Baskey's the membership manager at the Ontario Cycling Association. And tonight we have Steve Indig from SportLaw here to discuss ROWAN'S law and concussion safety. Steve has been working in sport law since 2003, I believe. He's, worked with numerous national sport organizations, provincial sport organizations, local clubs. A humble brag. It says over 650 on the SportLaw page, but I would assume it's higher. We've used the OCA has used Steve a number of times over the years at our club development and excellence summits, talking anything from risk management to incorporation to concussion safety and ROWAN'S law in the past. And tonight he's basically going to go over the ROWAN'S law legislation again, give everybody a bit of a refresher, as well as go over some of the items that are upcoming in 2022. And again, if you have any questions, please feel free to put them in the Q&A at the bottom of the screen. I will be monitoring that during Steve's presentation, and we'll be sure to either interrupt him or make sure that those questions are asked prior to the end of the webinar. And again, just for everybody, the webinar is being recorded. It will be sent out to all attendees and will be made available in the coming days. So Steve, I will pass it over to you.
Thanks, Chris, and good evening, everybody. Thanks for having me. It's interesting always to hear a little bit of your resume when I'm introduced to do these things. And as you said, started doing this in 2003. And truthfully, I never thought I'd have the ability to create a full-time career in amateur sport, particularly on the legal side. And I kind of used to make this joke and say, how many bylaws can I write? And the company has just entered its 30th year of existence in 2022. And I did just did an index of the number of bylaws I do have in my files, and the answer is over 2,000. So the answer is you can do a lot of bylaws in amateur sport. And really, again, happy to be sitting here to try and help sport. For those of you who haven't been to our website, it's sportlaw.ca. We just migrated, as Chris said, with a rebrand a couple months ago and had to move over our blogs. There's over 600 blogs on the site that relate to every topic in sport that you can think of. And you can see a few summaries there: legal services, governance, risk management, policies, complaint management, integration, equity, diversity, and inclusion. We've really tried to create a one-stop shop for sport. We've been able to grow our team since 2003 to 17 people. And everybody in our shop brings in a different skill set. As I said, we've tried to create that one-stop shop for amateur sport. And we kind of feel like if we can't help you, we'll know who can. So please feel free to use those resources. Like I said, the blogs are all searchable. All our contact information is on the site. So, if you ever want to have a quick question, please feel free to reach out. And as Chris said, I hope everybody gets a sense of me, even in the first couple minutes, that by all means, interrupt me, ask your questions. And if you're not comfortable asking your queries in a public setting, pop me an email or pop Chris an email, and we'll for sure get back to you with a response as quickly as we can. So what do we want to do today? A little bit of background on ROWAN'S law. How did it get created? And what are now organizations' responsibilities? And what does it mean to be the designated person? This is becoming a bit overwhelming for sport. We'll try to provide some clarity around that. And then, some of you, as you see, as we go through the presentation, ROWAN'S law may not necessarily be applicable to you depending on the demographic that you serve in your club, but there are two sides of this. There is the legislation, which requires us to do things, and then there's what we would call good practice or meeting our standard of care, particularly when we talk about litigation claims, and I'll talk a little bit about that at the end. So we'll get right into it. In 2013, Rowan Stringer was a 17-year-old rugby player who died on May 12th. On May 8th, she was tackled and showed symptoms of headache, exhaustion, and bags under her eyes. Of course, what we would now call symptoms of concussion. And she never told her parents or any adult about the headache. She was the captain of the team, and they were moving into the playoff series, and wanted to play and wanted to do well. And the cause of her death was multiple head injuries. She returned to play after receiving an undiagnosed concussion, and then received a second impact on her head and brain, which really is what caused her death. And as Chris said, I've been doing this for almost 19 years. And of course, there is a fair bit of litigation in sport, particularly what we call slip and falls. But rightfully so, we don't see too many deaths, which is the way we want it. But rather than suing Rugby Ontario and Rugby Canada and the local school association, Rowan's parents became advocates for concussion awareness, and they wanted to make sure this really didn't happen to anybody else's family. So of course we want to applaud the Stringer families for the work that they've done in this area to take a more proactive approach. Now, based on the advocacy work done by the Stringer family, a coroner's inquest was created. And the coroner concluded that there'd be 49 recommendations. There would be enhanced concussion awareness and treatment. There would be head injury awareness and prevention. There'd be removal from play protocols, return to play strategies, mandatory education, and better tools for coaches and players to identify and treat concussions. A committee was created to advise on the implementation of the 49 recommendations. Chris and I, some of you may actually know some of the people who are on the committee. A lot of them were medical experts combined with sport people, amateur sport people. And that committee basically, again, as I said, took these 49 recommendations from the coroner, and that led to ROWAN'S law, which became a piece of legislation that is applicable to sport organizations. So the application section is really, really super important. When we talk about law, people tell me all the time, it's against the law. And one of the first queries that I always like to ask is, well, which one? And a great example of that would be what we're seeing now with vaccines and human rights legislation and the Charter of Rights and Freedoms. You have to let me participate in sport because it's a breach of the Charter. That's not true. The Charter is applicable to government entities. We as sport providers are not government entities. Yes, we do have to follow Ontario human rights legislation, but the Charter doesn't apply to non-government entities. Even if you receive funding from the government, it doesn't make you a government entity. So understanding the applicability of law is super important, and one of the first questions that we always ask. Now, I'll say this with a catalyst. Some of you may be excluded from ROWAN'S law and its obligations based on the demographics of your club, as well as the type of services you're providing. But does it make sense to not do these things knowing that a standard is starting to be established in what we would call not only safe sport from an abuse and harassment perspective, but safe sport from a perspective of, are we participating and practicing in a safe environment? So I do think you have to look at this from two sides of the coin. And what's interesting about ROWAN'S law, the government usually mandates things on us and really doesn't provide a lot of resources, but we really can't say that about ROWAN'S law. And I know, Chris, you'll speak to this, but sometime during the presentation, the resources that are available for your club members, as well as what's been created by the Ontario government, it's all downloadable. We will post the links in the chat box, and you can see that downloadable stuff for yourself. Chris, maybe you want to, I don't know if that's a good segue to talk about it there, or we can hold off.
Yeah, so our club and team affiliation package, for those that are new over the last year or so, has had a number of resources that the government has come out with, everything from e-booklets to code of conduct examples for both athletes and coaches, to an e-learning module that is available. As well as we've added in a concussion policy template that SportLaw had created that basically touches on the key items that Steve indicated in terms of removal from sport, return to sport, some potential common symptoms. So All of that is in our club affiliation package and team affiliation package in 2021. It will be there again in 2022. But if anybody on this has a question or would like to see some of those resources, I know Steve put in the chat a link to the Ontario government page for sport organizations and schools. Most of the items are similar. There are a few that are specific to schools versus sport organizations. But again, if anybody has any questions on some of those resources, don't hesitate to reach out to myself or to Steve. We could definitely point you in the right direction. So.
Yeah, absolutely. Take advantage of the resources that were created for you. As I said, as Chris said, the ones that we've created were based on the government and our own experience. So please take advantage and don't feel you have to go recreate the wheel on the implementation of a ROWAN'S Law obligation. So full circle, application. So the legislation applies to a sport organization. Well, of course, what does that mean? It's a person or entity carrying out for profit or otherwise. So the amount of money you raise and the fact that you're volunteer based means nothing. And you are offering what's, of course, where we want to pay attention to, a prescribed activity in connection with an amateur competitive sport that satisfies other criteria may be prescribed. So it's not necessarily, of course, a very clear definition, but it is one that, of course, that we have to live with. So what's a prescribed? So first of all, you have to be a sport organization, a person or entity. So that would be if you're incorporated or not incorporated, you're for profit or not for profit. Regardless of how much money you make, you are providing an activity that relates to amateur sport. Part one. Part two, is it offering a prescribed activity? Are you training athletes? Are you, that should say coaching athletes. Are you coaching athletes? And are you holding tournaments, contests, and other competitions amongst athletes? So we need to be, one of those activities would make us subject to that application of the legislation. And of course, what they've done is they've created an age barrier, not a barrier, but divide. And you have to have at least one person under the age of 26 participating in your activities. Now, where you can see an exclusion is that the activities are not focused on competition. So if your club is completely recreational and you're getting together once or twice a week to simply ride, you may not be subject to ROWAN'S Law and its obligations. So the second bullet under the exclusions, individuals who ordinarily practice together, the competition of the teams may change and you are not keeping track of standings. You're not subject to ROWAN'S Law. So of course, what that means is the recreational organizations who have pickup basketball or a pickup ride, that may not be subject to the legislation. Again, because you do ordinarily practice together, but you're not competing, your end result is not competition. It's just really physical fitness. And of course, if you have people under the age of 26, that's out the window and you are obligated to meet the requirements of ROWAN'S Law. So I know that's not exactly 100% clear, but it's definitely what has been copied word for word almost from the legislation. So I'll summarize. If you are a sport organization, for profit or otherwise, incorporated or unincorporated, providing the prescribed activities of training athletes, coaching athletes, and holding contests with people under the age of 26 in your program, you are required to comply with ROWAN'S Law. If your activities are recreational and do not keep standings, then you're not subject to the legislation. So that's an analysis that you're going to have to do with the type of services you provide to see if you are applicable to ROWAN'S Law. I see a question there, Chris.
Yeah, so we have a question basically about, is there a definition or a clear definition between amateur sport and professional sport in this case?
Yeah, I mean, it's not defined in the legislation from what I can see off the top, what I've seen and off the top of my head. It really is defined, you're amateur unless you're paying your athletes. So that, of course, would be a very few bunch of people in Ontario, NBA, NHL, maybe lacrosse, soccer, high-level soccer. But if you're not paying your athletes and they are membership-based, You can see again the key definition is amateur competitive sport. Again, you wouldn't be paying them, so that would be a distinguishment in my mind on that definition. So Rowan's Law has been around for about 3 or 4 years now, and what's happened and what are our obligations? So there's an updated code of conduct to include zero tolerance policy for dangerous behavior, and that code has to be provided to participants, and parents and guardians all must sign that code in advance. Now, as you start to panic and saying, how do we do this administratively? We're starting to see it roll out, and it's been rolled out for years. Even my kids who are 8 and 10 are now getting involved in sport, and we're starting to see these documents on registration. And, you know, again, Chris, maybe there's an opportunity. I'll finish the slide here, and then an opportunity for you to talk about, again, how we've packaged that up for member clubs at the point of registration, so you don't have to go chase people down for a concussion code of conduct. There's mandatory collection of data, and all incidents are to be provided to the Minister of Health and Long-Term Care. That information is to be shared immediately with parents and guardians and other sport delivery partners with the consent of the athlete. So when we talk about cycling, it's really important that we try and notify the OCA that a concussion has occurred, particularly because if they're competing and a concussion occurred today and there's a competition on Saturday, we want to know, and we're not going to put that person in a position to continue having an opportunity of potential having multiple sudden impact syndromes. So sharing that information, of course, requires consent because it is personal health information. And if people fail to do so, then I guess there's very little we can do about that. But what we want to do is provide as much due diligence as we can. I sometimes shake my head, and I'm sure Chris has heard me say this before, you can't make this stuff up. And when a couple always stick with me, and last year we had an individual who was concussed. We saw it was in a training environment. The organization was aware of it. And they said, okay, you have to go to our return to play protocol, and please let your doctor know when you're able to come back. And you've gone through all the steps. I mean, again, we as sport providers, we're not the ones determining whether they're on step 1 or 2 of 6. That's up to medical professionals to do that. But this individual wanted to come back, and it was the daughter, she was 12 or 13, and she sent a letter to the club saying, I've been cleared to return to training. So they sent me the letter and asked me my opinion, and the letter was from an ophthalmologist, an eye doctor. And I really have to give the ophthalmologist credit because the way he crafted the letter was very precise. On examination of Jennifer's eyes, I see no signs of concussion. And I went, that's really smart of you, but that's absolutely not what we want. And for whatever reason, we sometimes have to protect people from ourselves. Where mom was trying to get her 13-year-old daughter back into gymnastics when she wasn't ready to. And we wrote the mother back and said, thank you for this letter, but could you please go to a neurologist or a medical doctor with expertise in concussions and get that letter from them rather than your eye doctor. So, you know, it is interesting that we sometimes have to save ourselves from ourselves. This is another big one that organizations are going to have to start identifying. At least one person present at all games and practices, in addition to coaches, who has a specific training in concussion identification and management. It's basically your spotter. And I'll give you more information as we move through the presentation on this particular topics. All coaches are required to complete annual training on concussion identification and management. And a committee, if a committee does not find sufficient evidence to support a recommendation, baseline testing. There was a lot of organizations and medical organizations selling baseline testing. We'll do a neurological test and indicate that you're here. And then if you ever get a head bonk, we'll be able to compare it to the results. The committee found there wasn't enough evidence to support that recommendation. And now it's really not being endorsed at all. Chris, I don't know if that's a shot for you to speak about registration, some of the OCA protocols.
Yeah, so as part of our membership forms last year, we basically incorporated some of the government resources like the e-booklets and the concussion code of conduct and OCA concussion policy within the waiver itself. So basically anybody who goes through and gets an OCA membership will have agreed to that. Though I do suggest that every club has, considers having its own code of conduct as part of its own registration. I think that's a good step, and I know a number of clubs here today already have taken that step. As well, any promotion of the resources, the e-booklets, the e-learning module from the government that you can put on your website would also help get the knowledge of this out there, because I think that's one of the biggest things is us as sport administrators and clubs, we can do so much, but if more people know about it, it becomes less of I'll say a chore and more of an expectation.
Thanks, Chris. So we're approaching year 4. We're entering year 4 of ROWAN'S law when it became law back in 2018. And what they've been doing is implementing the requirements in stages. Not every obligation was forced down on sport organizations. So effective July 1st, 2019, applicable to all amateur sport, there had to be mandatory education, mandatory immediate removal protocols, and return to play progressive guidelines. So if you don't have those in place, you are 2 years behind, and it's something you should be looking at. In addition to those obligations, you must now have participants sign and their parents sign that concussion code of conduct. And it's actually, as Chris said, it's in the OCA package. It's also, there's a sample on the link that I posted before. I'm looking at it right now, sample concussion code of conduct templates. And there's also return to play protocol templates available to you there. So there's a lot of free resources that you don't have to go out. What you do have to do, of course, is yes, implement them and make sure that your participants and their parents are signing these documents. Because again, from a legislative perspective, it's really important that we comply. And I will get into the really negative stuff closer to the end of the presentation on negligence and litigation, and breaching a statute or a law is a low-hanging fruit for a personal injury lawyer. Why didn't you do this, Chris? It says here you're mandated to do it. Well, I didn't know about it. I didn't want to do it. It's too onerous. That's really not good enough. We need our parents and our participants and administrators to review concussion resources, and of course establish that safe sport removal protocols and return to sport protocols. All of this stuff is available through the OCA, through the Ontario government. And those of you, and maybe some of you who are on tonight who have maybe already done this, you could share in the chat box or in the question box what you've done and some approaches that may help other clubs be successful in doing this. The code has to be signed by all participants under the age of 26 and by their parents under the age of 18. All coaches, team trainers, officials, managers, and who interact with individuals younger than 26 must also sign. The concussion code of conduct helps to prevent concussions. It's education. It provides health and safety precautions on concussions, and where you agree not to hide concussion symptoms and agree to take the time recovered. And as I said before, that's kind of an area sometimes we do need to protect ourselves or others. We're all, glorified Olympians, and even me at the age of, how old am I now? 46. I'm still playing competitive basketball, and yes, my knees hurt, but I still want to go out. Should I be going out? Probably not. But we need people to look out for us. So sometimes we're our own worst enemies, and I think you need to be aware of that. Some of the other resources that are provided, there is online training for age 10 and under. There is training again for that 11 to 14 and that 15 plus. It's on that link that I sent you. Please use it. Those resources must be reviewed again on a once-a-year basis by all participants under 26, all participants' parents of under 18, and all people affiliating with those people. And that's why we're really advocating for trying to get all this information signed off on at point of registration. So usually, yes, your registration package does keep getting a little bit longer. I do like to see, of course, name, address, phone number, the program you're signing up for. And the other areas we like to see is policy consent. You agree to comply with our policies. You may have an image consent. We get to take your picture and post your photo on our website. Third thing is you might have a privacy consent. I agree to allow the organization to use my information for certain purposes. And now we're adding the concussion requirements. So I do recognize that it gets onerous, but we are starting again to see it. And I think there's probably even software out there helping you to embed that in online sport registration systems. Can you give me an explanation of why under 26 changes the rules? You know, to be honest with you, I don't know the answer to that. I feel like in some respects it was a number that was randomly selected. I don't think there's any, there's not too much medical evidence. I think most people would say that your brain has fully developed by the age of 26, and that's the reason why they've selected that that number. Do I think it's a bit random? I would say yes. But again, the only reason I can think of would be that the brain would be fully developed there. Chris, is there anything you want to add on the resources again?
Nothing off the top of this other than sort of stepping away from kind of the government stuff would be, you know, any resources that actually talk about concussion and symptoms, things from Parachute Canada, as an example, would be great. And there is a link in our club and team affiliation package to the link on the Parachute Canada website about, you know, how to identify, you know, certain symptoms, noting that, you know, symptoms aren't immediate, and sometimes they don't present themselves in a way that's clearly identifiable to kind of you and I. But you know, it can be sudden. It can be days after the fact, weeks after the fact. But yeah, that'll, again, like I said, that'll be in our club and team affiliation package, and we can send out links to those resources to everybody here tonight.
Yeah, that's a good point, Chris. Another good resource is Parachute Canada. If you just Google Parachute Canada, you'll find tons and tons of resources on concussion and a lot of the things that we're speaking about today. They have really moved themselves to the front of the line on concussion management and the resources available. So again, take advantage of that. So we've talked about some of the obligations of your participants and their acknowledgements and undertakings. The organization, of course, has a few more. You must provide a removal from sport and a return to sport protocol. And again, you can use those templates provided by the OCA or by the government. The removal from sport protocol must have that designated person at events. They have a responsibility to remove athletes, to provide emergency action, inform parents or minors, and record the incident. They do not have to diagnose the concussion. They just have to use their common sense and remove the individual if there's a suspected concussion. And I've actually seen it firsthand. I mentioned my children, and my son plays competitive baseball in the summer, and he's actually 10. He started at a pretty young age, at the age of 6, and they were playing a tournament on the east side of Toronto, and a young player, I think he was 6 or 7 years old, took a bouncer in center field in the head and kind of fell over, started crying. They got the third out. This kid didn't stop crying, and the next inning started, and he came out to play center field again. And I have to applaud the tournament organizer. He walked out to center field and he said to this 6-year-old or 7-year-old, "How do you feel?" And the child said, "Not very good, quite dizzy." And the coach, the organizer, pulled him off the tournament, out of the game. And it was I think it was Toronto regional playdowns. It was important as 6-year-old baseball can be. And the coach wanted him back out there because they had only had 9 players. So if they took this individual out, they'd have 8. So again, that's the intent behind these designated people, is to make a reasonable decision depending on the circumstances of the incident. And again, sometimes, like I said, we need protection from ourselves or from our coaches or from whoever maybe not be making decisions in our best interests. Your return to sport guidelines, Again, it's not really, you're required to have them, but it's really not your obligation to enforce them. It's really something that the medical professional world has to do. And what we do is we give them guidance on what a gradual return to sport looks like. So, probably getting on a bike might be on stage 5 of 6. We would talk about one, light activity, maybe returning to work or returning to school, having the ability to read a book or having lights on without causing headaches. And then the medical professional would decide, okay, no, now you can do light workouts or light training, maybe try walking or running. And I think, to be honest with you, when we again talk about getting on a bike because of the dizziness and the blackouts, that's probably on stage 5 or 6 where we would return to full sport. But again, that obligation is put on the medical professions. What we can do is provide them the resource to say, give us an indication. I'll pick on Chris because I can see him. Give us an indication on Chris's rehab, for lack of a better term, and where are we with helping him try to get back onto the bike and getting back into a competitive training environment. So don't feel that you have the obligation or even the need to make that decision. You absolutely do not, but we do have our requirement by legislation to have that document. So I spoke a little bit more about the designated person. As I said, they have the ability to remove a participant. There should be zero tolerance. Always err on the side of caution. I mentioned my age before. I'm 46. I started sports at the age of 6, and I'd like to think I'm still going. I have a very, very large box of trophies. I have some really cool memories. I competed at the national, international level, but I'm really glad that I can work and walk, and sometimes we don't remember those things at the age of 16, 17, 18, 25, because that's the only thing we do know. And of course, it's a quarter of our life, that competitive environment, maybe a little longer, but we want to protect ourselves from ourselves. So really, again, that's the motivation behind this person, and we hope they make a reasonable decision. If they have a suspected head injury, that participant is removed. And if they don't, and they have to go see a doctor to get that letter to return, and it was just being overly cautious, I'm okay with that. Because if we were wrong and we let them continue to play, God forbid something serious happen to them. Training is not required to be the designated person. You just have to make a judgment call. You have to review the concussion resources, look for the signs and symptoms, be aware of them. And again, remember, you're not acting as a doctor, as a physician. You're not making a diagnosis. You're applying common sense to protect ourselves from ourselves. Always assume the worst, and no competition is so important as to allow them to potentially have life-altering decisions. A client of mine, I think Chris would probably know who it is, actually was walking at their house, and their son had a chin-up bar in the doorway, and for whatever reason, it fell on her head. And she couldn't work for 6 months. She ended up working basically in a black room. She couldn't have any lights on. And that was just a simplicity. That was just from something falling on her head in her doorway. And it really kept her out of her employment and her ability for over a year. So we just, again, want to be protective of that. So like I said before, what are the things that we can do to help you resolve all these obligations? Develop a concussion policy for participants that requires a review of concussion awareness resources. Provide the links. Let them read for themselves. Describe how you recognize a concussion, observable signs, include the code of conduct, describe the removal from sport and the return to sport protocol. All of this is in your OCA package. Right, Chris? Yes.
Yes, it is.
So, and as I keep harping, that's why we really like trying to do this at the point of registration. You can just embed the links and the I agrees into your registration form, where you have a link to the concussion awareness resource that they must review. There has to be a link to the concussion code of conduct that they must review and indicate their agreement and sign the code that they've seen these. And again, you can do this, I'd like to think, fairly simply with online registration platforms with the resources that we are providing you. So again, even if you are not subject to ROWAN'S law because of the type of service you offer, or the demographics or age of demographics of your participants, implementing the requirements really shouldn't be that onerous. And it's really probably not that crazy as well to have somebody on your rides who's that designated person to watch out for each other. So again, I'll talk more about that when we talk about negligence shortly. So practical implementation may be challenging, but most of the materials are already developed. Consider that online form and keep track. Because again, God forbid you're in litigation. Chris, you're with Toronto Cycling Club. Steve Indig fell off and got a concussion. Did you implement the concussion protocols? Yes, I did. Here's Steve's proof that he signed the document November 2nd at 8 p.m. on our online registration platform. You can see what we've taken an example here for what Swim Ontario does. And again, it's just something that they've used, that they've implemented in their Team Unify. It's an online registration system for their 2019-2020 season. So I'm sure, Chris, there's some stuff in the package as well. But again, any sort of clarity that any of you need in implementation, just pop us an email. We for sure will point you in the right direction.
I'll just touch on, I've seen a few clubs set up, for those that are on CCM Bikes, have their own setup page through that registration provider. I've seen clubs that have set up basically a page which says, okay, once you've submitted all your information, where there's usually a waiver section, they've incorporated their concussion policy and a yes, I agree to this. And then next page is the concussion code of conduct and a yes, I agree to this. And if it's a parent, a second person agrees. That's probably, if you're using an online provider, your best way of doing it. To Steve's point is just, it does add another page or two, obviously, to the process. If you're using something like CCN, but in the long run, obviously, you want to collect this information in case something was to come up. So yeah.
Well, that's a great segue to this next topic that we're going to talk about. So, we talked about what's required under the statutory regulations under ROWAN'S law. And then there's what we would call tort, negligence, litigation, being sued. And look, I hear this all the time. Oh, so-and-so won't sue me. He's my friend and we ride together and we work out together. And you know what? I hope that's true. But I tell you, sometimes people don't sue for vengeance. They sue because of necessity. So I'll pick an example of John Smith, who has 2 kids under the age of 10, a big mortgage, and a pregnant wife. And God forbid he falls off his bike and he becomes paralyzed, injured, paraplegic, can't work for years, needs medical rehab, needs physiotherapy. Who's paying for that? And meanwhile, he has two kids and one on the way to raise. Who's paying for that? And we sue sometimes because of necessity. So in order to be negligent, you have to say yes to the 4-part test you see on the slides. So do I owe a duty of care? Well, likely I do if they're riding within my club, they're coming to my trainings, they're coming to my practices, they're coming to my competition. Yes, I have an obligation to make sure they're okay. And that usually that first part of the test in sport is pretty easy. Check the box. Yes, I have a duty of care. Did I breach my standard of care? And how we figure that out is looking at 4 factors, which I'll talk about in a second. The third part is there has to be actual harm or loss. So if you fall off your bike, you get back on and you finish your 50K ride and you go home with, maybe a scratch or 2, there's no harm. You break a leg, you get a concussion, you can't work for 3 weeks, you need physiotherapy. There are things that need to be compensated for with money. And of course, the last part of the test is it all has to correlate. And if it doesn't all correlate, then you're not negligent. But what we want to do here is say no to one of these questions. So do I have a duty of care? Likely, if it's in our program, I do. But did I breach my standard of care? So how do I figure out what that is? Sorry, there's the slide on duty of care. Anyone I know who could be affected by my actions. In sport, like I said before, coaches, athletes, clubs, participants, usually that duty of care obligation is pretty black and white in sport. But where I have the most ability to manage things is on the standard of care. And I want you to think about it like a line. And is that line really high? Is that line really low? Is that line in the middle? And what we do to help figure that out is common sense, really. So I'm going to work backwards. What's your gut say? Should we go out on this ride at -3 with snow that just came down and no one has experience riding in the snow, nor the right equipment or the right tires? This is a really bad idea. Follow your common sense. And that'll help you establish what would a reasonable person do in a similar circumstance. One of my favorite stories on common sense is, hi, Steve, we're an artistic synchro club. We're going to a tournament in California. And do we need chaperones? I said, how old are the girls? 13. I said, do you have kids? She said, yes. I said, how old? She said, 14. I said, perfect. Would you send your 14-year-old to California without a chaperone with 13 of her friends? Absolutely not. That's your answer, right? Common sense. Then there's the unwritten rules. So, you know, Chris, I don't know how many OCA clubs are there, give or take.
Pre-pandemic or post-pandemic? In a good year, probably about 100, just over 100 clubs and a number, but another 50 to 60 teams.
All right, let's go with 100. So what happens is we start creating trends in the industry, and those are what we call the unwritten, unpublished standards. Things just keep happening. People start doing different things. Some of the clubs may say, you know what, implementing Rowan's Law, even though we may not have to, is a brilliant idea. Let's say 90 of those clubs do that, and the other 10 just don't. Why? Everybody else is here, but you're down here with respect to your risk management standards. And that ties into the case law. The case law about sport and the requirements are really multiple tiers. You have to have progressive training, proper supervision, and adequate equipment. And also do what a reasonable person would do in a similar circumstance. And again, that ties back to what other clubs are doing, because that's who you're going to be compared to. And the best one in litigation is written standards. Chris, you're from Toronto Cycling Club. Do you offer competitive amateur services to people under 26? Yes. Do you attend competitions? Yes. Did you implement Rowan's Law? No. And my client here has a concussion and can't work for 2 years. Showing a judge that you haven't complied with that written regulation is a lawyer's dream. And that's absolutely what we don't want to happen. And I always say, you know, I love policy. Policy provides you guidance, policy provides you education, and it also sets a framework on how we manage things. But if you can't live up to your policy, don't have it, because it's Exhibit A for me to say, did you follow your policy? Now, remember, you likely have legislative requirements to do so. If you don't, you want to make sure that you've hit those exemptions and that you have a legal argument to say otherwise, because go back again to our first slide. If somebody sues, it may not be in vindictive fashion. It is again because of necessity. And where do we have access to money? Well, the OCA has a $5 or $10 million insurance policy that we can tap into to be successful in covering our damages. If there is no insurance, then that's when it becomes a personal liability, and that's when we do the incorporation presentation. So you can see based on this slide, what we want to do is end up in that middle, in that upper white box. There are actual people in Canada who are paraplegic from playing sport and did not get a dime because the organization was able to prove they provided progressive training, adequate supervision, and met their standard of care. And that's where we want to be in the white. So we're not saying that we need to be perfect and that injury is not going to happen. What we do need to do is to be reasonable in our due diligence of creating a safe environment. And yes, that threshold moves up every single day. I understand that. And then, you know, the standards of 10 years ago, let alone 20 or 30, are far different than they are today. Some good, some bad, but it's just the reality of where we are. So, again, I'll go back to this slide, like, please do a quick risk management assessment of where you are on an overall safe environment, including adding concussions to that conversation. So when we talk about risk management, it's really, I love adding it to your board meetings, your planning sessions. Ask these 3 questions. It'll take you 3 minutes. What can go wrong? What are the things that can go wrong today with this program, with our club? And if it does go wrong, how is it going to impact the organization? What are the consequences if it does? And then thirdly, what can I do to avoid that risk? Is it education? Is it not doing it? What can I do? And you'll see by doing that risk management assessment, even in those 3 minutes, you'll be able to probably solve a lot of problems. Hey, and Chris, help me out here. Hey, we're going for a training ride. Do we have a cell phone? Has anyone checked the weather? Do we have enough water? Is anybody allergic to bees? Do we have an EpiPen? If we do go out there and someone gets stung with a bee who's allergic, what can go wrong? Well, they could die, right? Depending on where a ride is and the access to a hospital or an ambulance. How can I control that? Hey, Chris, do you have an EpiPen? Can you bring it with you? You make sure we have that with us. And you see, in about 90 seconds, I was able to hopefully manage a potential catastrophe of going on a ride with somebody who has bee allergies. And if you do that again with all of your activities, I think you're going to be able to answer a lot of queries and manage a lot of your issues, particularly again on Rowan's Law. Don't feel you're alone on the implementation of this project. Chris is all over this stuff. We are here to help you if you're having problems and Chris can't answer your questions. There's resources available at Parachute Canada. Don't go out and recreate the wheel. Even if you are not subject to Rowan's Law, we of course highly recommend implementing it because truthfully, it's just good practice. And the question that came in before about why the age of 26, again, I think it's a bit irrelevant simply because it was probably to create less responsibility to provincial sport bodies or sport organizations. But there's nothing wrong with making sure that we're all protected. I see a question there, Chris.
Yeah, so I'm gonna paraphrase it because I think I had the same question earlier. So if in this example, an OCA registered team requires membership at an OCA registered club. If that club has the resources posted and gets sign off, does the team require that the individual member then need to review the concussion resources again, sign a code of conduct? And this sort of goes back to, I guess, even at the provincial level of if the OCA membership form or membership waiver says you've reviewed the guidelines, you reviewed all the concussion resources that are applicable to you, and you've signed off on a code of conduct, would a club need to collect that? Should a club need to collect that? And which items would they need to collect for them versus OCA?
Yeah, it's a really great question. And I'll give you a bit of a schmozzled answer. And the reason I say that is because I think, we're seeing it more so even with vaccines right now, where organizations are passing off the responsibility of checking vaccine status. We're seeing that particularly with facilities, and the facilities are saying, well, if you want to rent our ice time, you've got to go do the check by yourself, rather than the obligation being placed on the facility. And I see it in some respects. Again, we have to go back to the legislation. There's not a distinction between, well, I'm a member club of a provincial sport organization. A sport organization is anybody providing, again, training, competition, and that type of environment. So I really think it's something that both of you have an obligation to do. Are there strategies that you can implement to maybe streamline it? Maybe something, Chris, I'm just throwing this out there, and I'm sorry if I'm throwing you under the bus, where we say at OCA registration, I agree to the OCA's concussion policy and insert name of club, right? But again, I see a distinction between the services being offered and the competitions being offered. You know, the OCA is really not doing training, right? They're offering competition, resources, education, things like that, versus a daily training environment. Maybe you want to add to that, Chris?
Yeah, so I mean, the current setup with the membership form is basically a OCA concussion code of conduct, concussion policy, and the government resources. Our suggestion would be, like Steve said, that each club or team have definitely have their own policy, which would then touch on removal and return to sport protocols. I believe in the template, it does embed the resources as the e-booklet resources as well. And then your own concussion code of conduct, just A, so that it takes out any of that sort of ambiguity of, you know, sport organization, but also B, because while we could sort of blanket, you know, it covers OCA and OCA club or team, we can't get into specifics, obviously, with the membership form, without it sort of, because the form is just a generalized member form for the OCA. So now there is a question in the chat, so I'm going to just bring it up. Going back to sort of the competitive sport and club ride. So we deciphered that this is focusing on competitive sport when we're talking Rowan's Law legislation, versus a recreational activity. What if your club, I guess, is it specifically the activity you're participating in? Or is, if your club is running both a competitive and a recreational program, that somebody might be, you know, participating in both, but their injury occurred in, say, the club ride activity?
Yeah.
How does that apply?
It hasn't been tested yet, Chris, to say a distinguishment between the activities. I, again, go back to the legislation. It says, you know, you're an amateur sport organization providing training, coach-led training to a competition. It's really the threshold. Do I think you're exempted if you're, you know, a competitive stream versus a recreation stream? No, I don't. I think it becomes the entire organization's obligation. So if you're simply, I'm trying to even think of, like, those of you who are familiar with Toronto Sport and Social Club, they keep standings. They have people under the age of 26. They are likely subject to Rowan's Law. I think where you would see it not be subject to it is, basically you're a recreational organization that offers, recreational rides on Sundays. That without a coach present would be, for people under the age of 26, you would be exempt. But I think if you are offering, recreational and competitive programs, I would say that the entire organization would be subject to that. Any questions? I've run through all the slides that I prepared for tonight. Again, if you're unsure about certain queries, and like I said, you may not be comfortable asking them in a public setting, pop Chris an email. There's my contact information on the slide before you. We'll also share the PowerPoint presentation. Chris, I'll get it to you after we disconnect tonight, and you could pass that out to the attendees. Yeah.
That's good. So we'll give another, minute or so for any other questions to come in. But like Steve said, if anybody has any that they want to ask offline, don't hesitate to send us an email, give Steve a call, give myself a call. Again, it's definitely something that I think a lot of sport organizations are kind of questioning if they're doing it right, doing it enough. So, we want to make sure that everybody's as comfortable as they can be to get this set up. We have a question in the chat. So Dave, yes, our concussion policy will be updated shortly to reflect the 2022 obligations as well. So.
Chris, sorry, I don't know if it was me, Chris, or you, it paused.
Sorry, yeah, so there was a question from somebody about the OCA's concussion policy. So the current one posted is missing the I believe the removal from sport aspect. So that is created. It is to be posted. It will be sort of a part of our registration. But yes, that will be set up. So there's a question in the chat. So yeah, so the question in the chat, again, just confirming. So a non-competitive ride for a club, that basically, let's say, is non-competitive, ROWAN'S law would not apply in that case.
Yeah, I don't think you can distinguish between the program. So if, again, I'm making this up, and if there is a Toronto Cycling Club, I apologize because I'm totally making this up. So if there's Toronto Cycling Club that offers the competitive stream and the recreational stream. So the competitive stream meets 4 times a week. They have a coach. They're gearing up to provincial championships. That obviously would fall under ROWAN'S law. And then there's the individuals who are just coming on Sundays and doing a 50K ride and enjoying their Starbucks with the group afterwards. I don't think you can distinguish between the activity because it's the same organization. I think you have to distinguish it based on the entire service available to the membership.
So last chance for any questions on at least this webinar. Again, we'll definitely trying to help everybody get through this. Make sure that this is something that they're able to set up either as part of their registration or that they're comfortable with. Just to confirm, when we talk about the designated person, again, so I think some clubs always have a concern over volunteers and could this scare away volunteers. We're not asking an individual to diagnose a concussion. We're asking a person to err on the side of caution, to essentially feel that they have the liberty to pull an athlete if they may have suffered a crash or went down and they suspect a possible head injury. Is that correct?
Yeah, absolutely, Chris. Again, it's err on the side of caution. It's a person to make that tough decision when it's necessary. That's really what it's about. We're not asking you to diagnose. You use your reasonable education. Geez, Chris just fell off his bike. His helmet is cracked. I think your ride is over and you need to go to the hospital, right? That's really it.
Perfect. So if there are no other questions, I will let everybody have the rest of their evening. And again, don't hesitate to contact our office. We're out here Monday to Friday, 9 to 4, and Steve is always available. You can call him at 6 a.m. in the morning, I'm sure, and he'll be eager to answer a call.
You'd be surprised what time the phone rings.
But yeah, thank you everyone for coming. And as part of our sort of club webinars, there will be some more coming up in the near future. But thank you everyone, and you have a great evening.
Good night, everybody. Thanks for listening. Thanks, Chris.
Thanks, Steve.